Hello, and welcome to week 4 of legal writing. Last week, as you may recall, we analyzed the law for our client, Dr. Hathaway, to determine whether or not the non-competition covenant in her employment agreement with her former employer was enforceable. And so this week we want to talk about a framework for conveying that analysis in writing. And the framework we're going to talk about for a few minutes today is incorporated in all legal documents so that there's a predictable format for such documents. And the framework we're going to talk about has an acronym, IRAC, I-R-A-C. So let's talk about this for a few minutes. So the I in IRAC stands for issue. So the first thing you do when you're conveying your analysis is to identify the legal issue. The issue can be general or it can be specific. So let's take a couple examples. For our client, Dr. Hathaway, if you were to identify the general legal issue, it might be something like, is the non-compete in Dr. Hathaway's employment agreement with her former employer enforceable? If you were to identify the specific legal issue, those are also sometimes called sub-issues. An example in our case would be, does the specialist have a protectable employer interest? When you're identifying the issue, if there's a statute, often the issue will come from the statutory language. That means it's usually a disputed or an unclear element. If there's no statute, often the issue will come from a common law test, as it does in our case with Dr. Hathaway. In that instance, the issue would be either an element in dispute or perhaps a factor in dispute. The next part of this legal framework is the R, or the rule. And the rule stands for the rule of law. This will come from the source of law. And as you know from some of the other courses you've taken in this program, the source of a law could be a statute, it could be a case, or it could be a regulation. For our client, Dr. Hathaway, the source of the law is case law in Ohio. So for example, if you were to identify the rule in our case, it would be something like a non-competition covenant is enforceable when it is reasonable. Then you could go on and you could define the rule even further by describing what it means to be reasonable. The next part of conveying your legal analysis is where you apply the rule to your client facts. That's the A, the application. When you are applying the rule to your client facts, you only want to focus on the most relevant facts with respect to that issue. There's no need to reiterate the facts of your client's case or to tell a story. That doesn't belong in this portion of your analysis. You might even focus on a particular set of facts for each issue. So for example, if we were going to focus on whether or not specialists had an enforceable, protectable employer interests, we would only focus on the kinds of facts that relate to the employer interest. If we were instead going to be discussing whether or not enforcement of the covenant would be an undue burden on Dr. Hathaway, we would be discussing facts related to what makes an undue burden on an employee. The final element that you want to discuss in your legal analysis and convey is the C, or conclusion. In the conclusion, this is where you answer the overall question, or perhaps just a single issue within the overall question. You often start with a yes or a no, because you're giving a direct answer to the question or issue, and you usually incorporate the issues within that context. After you go through this IRAC analysis, you'll be able to convey your analysis in writing. And we'll go ahead and we'll talk about a couple different ways to convey that analysis.